Back to the joint hearing, the House and Senate Judiciary Committees, fair and impartial policing oversight, and we're going to hear from Will Lambeck. But before we do, I just wanted to, when we were taking a break, I heard from some folks as far as concerns on data collection and such, and that really wasn't intended to be the focus. I know that it was brought up in a couple questions and also by legislative counsel. Really, the data collection issues haven't been the focus so much as really the immigration issues. And I want to just let folks know that I am planning on, probably it will be just House Judiciary Committee really focusing on data issues beyond just fair and impartial policing. So that will be coming, and we will be getting that in this session, before we quit. And it's been a plan for a while. So I just wanted to make sure that folks understood really what the focus was today. And now over to you, Will, if you could introduce yourself for the record and proceed.
Thanks very much, chairs, representatives, senators. My name is Will Lambeck. I am with the organization Migrant Justice. Pleasure to be here to speak with you all today. Migrant Justice is a Vermont-based grassroots organization founded and led by the community of immigrant farm workers in this state. Organizing for human rights and economic justice. I'm glad that there will be more discussion on data later because my remarks are about the FIP policy and in particular the elements of the policy and statute that pertain to immigrant communities and immigration. And to provide, I think, a little bit of an update or clarification from previous testimony that you heard. Immigration provisions were initially included in the Attorney General and Vermont State Police model policies around 2014. Those were later included in the first unitary model policy developed by the Vermont Criminal Justice and Training Council in 2016. And so really have been part of the policy throughout. And they've been added in precisely because they were needed to make real the policy's prohibition against discrimination and profiling of immigrant communities. So this language was included in order to give teeth and guidance to officers to ensure that that profiling was not happening. So I think there's been very good work from the legislature over the past decade plus on this issue. And I think Vermont has a lot to feel proud of. It was once quite commonplace that if an immigrant were in a motor vehicle as a driver passenger and that motor vehicle was stopped by law enforcement, it was quite common that immigration authorities would then be called to the scene of the traffic stop and that person would then be detained and deported. Thankfully, that is no longer common in our state. However, and this is a big however, there are still examples of actions by Vermont law enforcement agencies that result in civil immigration enforcement. And specifically, the model policy was weakened in 2017 in response to threats from the first Trump administration. And I know earlier, Executive Director Brickell objected to the use of the word loophole. So I won't say loophole, but I will say that there was a vague language introduced in the policy to allow for and justify the involvement of Vermont police with federal immigration authorities. And just a couple of examples, and these have all been publicly reported on and backed up by records requests and body cam footage. But there have been examples of sheriff's deputies in Franklin and Grand Isle County calling for Border Patrol backup for the purpose of immigration enforcement on farms in Vermont. In both those cases, deputies elected to contact Border Patrol only after learning about the nationality of the individuals involved and when other options for backup were available. We had a sheriff's deputy in Chittenden calling backup from Border Patrol to the scene of a traffic stop on I-89. Later on, he said that he was investigating human trafficking, when in actuality, this was a case of a double date of 4 people going to the Applebee's. Sheriff's deputy in Orleans County called Border Patrol to assist in translation during a traffic stop in violation of the policy itself. And he was later caught on tape being counseled by a colleague to avoid the use of the quote unquote magic words when he wants to call immigration enforcement in the future.
Just curious what the years were that the 4 or 5 things that you mentioned, what years did they have?
I don't have them precisely in front of me right now, but the Franklin County was 2017, Grand Isle, I believe, was 2019, Orleans, I believe, was 2020 or 21. But they again have been publicly reported on, so I'd be happy to provide that information. And then just the last example.
I just think it's important as far as the years go, because if
Yes.
the last one that you mentioned is 2021, it does show that things could be improving.
Certainly. And the last one I'll mention is an incident where Vermont State Police sent information about a detainee in their custody to Border Patrol, resulting in that person's detention and deportation. This was the case of a farm worker named Dorby Martinez. And because of the deterioration of their health while in immigration detention, they died shortly after being deported to Mexico. So there have been significant improvements, to your point as well, in the policy, but.
Let me ask you just a follow-up question to those incidents. Were those reported as violations to the Vermont Criminal Justice Council?
In those instances, there were internal investigations done by the agencies in many of those. Because of the I guess confidential nature of the investigations in the Criminal Justice Council, we inquired in some of the cases whether or not investigations were being done in the CJC, and did not get a confirmation of that.
Okay, fine, thanks.
But I will say, to our knowledge, none of the officers involved in those instances of collaboration faced any repercussions. So there have been improvements made, but there's still a long way to go. And the recognition of that was the impetus for the improvements to the model policy that were made by the Criminal Justice Council last year. And as you've heard, that was a long and arduous process with a lot of stakeholder input. Many members of Migrant Justice spent hours talking with law enforcement officials, reviewing drafts, participating in meetings of the Criminal Justice Council. And ultimately, the model policy that was approved by the Criminal Justice Council last year was an improvement. It strengthened protections above and beyond what was in the 2017 model policy. But we don't believe that those improvements go far enough to protect immigrant communities in the state. Now, prior to the adoption of the model policy last year, there were 9 jurisdictions in the state that had implemented policies that exceeded the protections in the state model. Those jurisdictions were Winooski, Burlington, Richmond, Shelburne, Brattleboro, South Burlington, Hartford, Norwich, and the Addison County Sheriff's Department. Some of those changes were made under the department's own volition after requests from Migrant Justice, and some of them resulted after the passage of municipal resolutions, and in one case, municipal ordinance advising the police department to adopt those recommendations. Now, collectively, those policies are known as the Winooski model, because Winooski was the first to adopt those enhanced protections. When the statewide model policy was updated by the Criminal Justice Council last year, many of those jurisdictions, as well as some others, expressed interest in either maintaining or implementing the enhanced protections in the Winooski model, while they simultaneously updated their policy to conform with the updates in the new model. And you heard from Executive Director Brickell earlier about 2 of those examples, the towns of Hartford and Richmond, where discussions are ongoing about to what degree they'll be able to update their policies. But those are not the only jurisdictions that are interested in maintaining or implementing enhanced protections. However, yes, Senator.
The enhanced protections that were in the Winooski model under the 2017 Fair and Impartial Policing Policy were approved and in line with that policy. Yes.
Yes.
Okay.
Those were all certified as compliant with state statute by the Attorney General's office.
Now, does the new Fair and Impartial Policing Policy, the 2024 policy, does that meet those enhanced protections? Or would these still be above and beyond what's provided in 2020?
many of them would still be above and beyond what's provided for in the 2024 model policy.
And do you have a sense of what the barrier, so I guess what I'm struggling with is if they were approved under a previous less protective policy, what would be the barrier to them being approved under a more protective 2024 policy?
Right. That is the question, and what I hope that the committees here will be able to clarify today, because the agencies have been informed by the Vermont Criminal Justice Council that they cannot strengthen policy protections in one key piece, and so I'll focus in on this one piece. That is whether or not the agency can restrict officers from sharing the immigration or citizenship status of individuals with federal immigration authorities. So to your question, Senator, we believe this is a reversal of the previous policy from the Criminal Justice Council and the Attorney General's office, which had previously certified the policies in the 9 jurisdictions. So to get in on this, I want to talk about Act 41 of 2019, which was the last time that the statute 20 VSA 2366 was updated by the Vermont legislature for the purposes of this conversation. So in Act 41, there were a couple amendments made to the statute, and I want to read off the amendment in subsection A. So this is talking about agencies' responsibilities to adopt policies that meet the requirements of the state model. And the amendment reads, such agencies and constables may include additional restrictions on agency members' communication and involvement with federal immigration authorities or communications regarding citizenship or immigration status. Agencies and constables may not adopt a policy that allows for greater communication or involvement with federal immigration authorities than is permitted under the model policy. Now, when Act 41 was passed, this was sort of called colloquially, it's a language to show that the model policy is the floor, but not the ceiling. ACLU will be testifying after me, and they're going to go into more of the legislative record and talk about the testimony that was presented during the consideration of this bill. I can share from my perspective that this bill is based on language that was written collectively by myself, by ACLU, and by David Scher, who at that point was representing the Attorney General's office. And this was meant to be a compromise between parties. Migrant Justice and ACLU were under the impression, or felt and still feel to this day, that the model policy should be strengthened to prohibit this type of information sharing. The Attorney General's office and others felt that due to restrictions from federal law, that it would not be wise for Vermont to prohibit that type of information sharing in the model policy, but that municipalities and county agencies could be free to reach their own conclusions on this matter. So the controlling federal statute, as you all have already heard, is 8 USC 1373 and 8 USC 1644. Collectively, we'll just sort of refer to those as 1373. This is a federal statute which has come under a lot of scrutiny in recent years, but it's been on the books since the 90s, directing that states and municipalities shall not restrict information sharing with federal immigration officials regarding information related to citizenship or immigration status. So under the Attorney General's office, read, the state should not restrict that type of information sharing, but under Act 41 of 2019, they said that agencies themselves may further restrict that type of information sharing. So this was passed in 2019. Following that, over a couple of years, these 9 jurisdictions implemented policies that did restrict this type of information sharing. Those policies were certified by the Attorney General's office and Criminal Justice Council. And now, over the past several months, the Criminal Justice Council has communicated to jurisdictions that such policies will not be certified. And to justify that communication, they point to subsection F of 2366. And subsection F reads...
What, 2366?
20 VSA 2366, which is the FIP statute that Ledge Council read from this morning. So subsection F, this comes from 2017, and says nothing in this section is intended to prohibit or impede any public agency from complying with the lawful requirements of 8 U.S.C. 1373 and 1644. And to the extent that any policy or practice conflicts with those lawful requirements, that policy or practice is to the extent of the abolished. And I'm paraphrasing there a little bit. So this was passed by the legislature in 2017. And what the Criminal Justice Council is saying is that because of this language, they can't certify these policies, and that if the legislature meant what they said when they passed Act 41 in 2019, then they should have also repealed F. However, we disagree with that analysis. This language originally comes from Act 5 in 2017, which was introduced by the late Senator Sears. And during the discussions around that, we advocated for, as did others, the specific language of the lawful requirements of 1373. And the reason why that word, the lawful requirements, is important is because there are serious constitutional concerns about the legality of 8 U.S.C. 1373. Courts are very much split on this matter, on whether or not it's a violation of the 10th Amendment's anti-commandeering principle. And so essentially, what 20 VSA 2366 says is that it's up to each jurisdiction to determine what those lawful requirements are. The Criminal Justice Council and the Attorney General's Office do not represent municipal law enforcement agencies, nor do they represent county sheriffs. And so they shouldn't be in the position of determining for those agencies what the lawful requirements of 1373 are. And now going back to 2019's Act 41, I'm now going to read from subsection B of the statute, which is the final line, which again, the legislature passed in 2019, a finding of compliance with subdivision A1, which is what I read from previously. So a finding of compliance that an agency meets the floor of the state model policy. The finding of compliance shall not constitute a finding of compliance with any other applicable law. So this was written, again, jointly drafted by the ACLU, the Attorney General's Office, and Migrant Justice, to say that when the Criminal Justice Council and when the Attorney General's Office are determining, does an agency's policy meet the minimum standards in the state model policy, the only thing they should look at is that question. Does it meet the minimum standards? They don't, and they actually cannot look at does that policy comply with any other statutes? So we believe that it's very important that the legislature clarify for the Criminal Justice Council and the Attorney General's Office the intent behind 2019's Act 41 and the intent behind the current statutory language in 20 VSA 2366. And that upon clarifying intent, our hope is that the state will permit law enforcement agencies to provide additional protections to immigrant communities within their fair and impartial policing policies as the law intends. Thank you.
Senator Mahalski.
I have a couple of questions, and the ACLU may answer some of them, but the subsection F that you pointed to, that was in place when the 9 enhanced policies were approved previously?
It was, yeah.
Okay. And when those policies were approved, did any of those communities experience any litigation or loss of federal funding?
They did not, no. It may have been the case that some of those agencies chose or elected not to apply for some discretionary grants from the Department of Justice, but to our knowledge, no agency was rejected for any funding that they applied for.
Okay, great. And to your knowledge, and you may not know, my understanding is there's also an international law explanation of lawful that came as a result of the Nuremberg trials and what happened in Germany. When we discuss lawful in these contexts, are we also utilizing that international definition of lawful?
That I
Okay.
couldn't speak on, Senator, sorry.
Okay.
So using Hartford as an example, I mean, has there been a decision by the Attorney General rejecting the policy? Or, I mean, so, I mean, is there some action that actually can be litigated if, because that's another place that intent of this various language could be determined is in court. And I'm wondering if that's something that has been pursued or could be pursued.
It is our understanding that Hartford and other agencies have been informed by the Vermont Criminal Justice Council that if they attempt to retain the enhanced protections in their policy, that policy will not be considered compliant by the Criminal Justice Council, and thus the agency will be assumed to have adopted the state model. And I know the Attorney General's office will be testifying later. There's a memo that was sent to Richmond, and I believe has been sent to other agencies. I'm reading a version that was dated December 9th that lays out the Criminal Justice Council's reasoning for why they are rejecting those policies. And then to the question of litigation, I don't believe any litigation has been filed, and it would certainly be our hope that cities and towns wouldn't have to be in the position of suing the state government over this. Our hope is that the legislature can clarify the intent behind Act 41 in 2019 and impress upon the Criminal Justice Council the importance of following the laws intended.
Other questions? Not seeing any. Thank you very much for being here. That's a very helpful testimony.
Thank you very much, Mr. Chair.
So Falco Schilling, please join us. So I'll just jump right with the question that I kind of left. But I mean, is this something that can be challenged in court?
Potentially, I'm not going to get into any of the merits of potential litigation on this.
Yeah,
but I think it is something that
If it is something that is justiciable, I guess.
potentially, but I don't want to get into speculation around that right now.
Sure, fair enough.
And for the record, my name is Falco Schilling. I'm the advocacy director of the ACLU of Vermont. I appreciate the opportunity to testify in front of you today about the fair and partial policing policy. Recognizing the time, I feel very lucky that a number of other witnesses have covered most of the ground that I was going to speak to, but I think I'm going to re-highlight a couple of points in relation to this policy and some of the concerns we have, and also some of the ways that we think that this is working well. So there's both sides of that coin. So this is an issue of great importance to many people, and we've heard reference numerous times in the past few weeks within this building to the fair and partial policing policy as legislators have grappled with what they can better do to support immigrant communities in the state and to ensure that you're prioritizing the use of state resources to address priorities of the state instead of using them to support federal immigration initiatives. And as you've heard, the model fair and partial policing policy is mandated by statute and speaks to many different scenarios where law enforcement is interacting with the public, as well as interaction between the state and local law enforcement and federal immigration authorities. We are strongly in support of having this policy on the books and have spent many years working on it in different avenues. A lot of this work was led by our legal director, Leah Ernst, who's been working on this one way or another for about a decade at this point. So if there's questions about historical context, I will do my best to answer them, but have not been through all of that in the same way that she has. So this does go back quite a while. You've already heard significant background on the policy itself, as well as its development. So I wanted to take my time to speak to some of the concerns specifically related to certification and to compliance, both sides of that coin. So as I think Will did a very good job laying out some of the concerns in terms of certification in relation to the 2016 amendments. So under 20 VSA 2366, every law enforcement agency is required to adopt a fair and impartial policing policy that includes every component of the model FIP. It can, if they wish, include additional restrictions on communications and involvement with federal immigration authorities. This is explicitly spelled out in A1, which was read for you earlier. And it makes clear that the CJC model policy is the floor for municipalities, but it is not the ceiling, and that municipalities could impose more restrictions on communications with federal immigration authorities. Subsection 2366B requires that the Criminal Justice Training Council, in consultation with the Office of the Attorney General, shall review the policies of law enforcement agencies and constables and are required to adopt a policy pursuant to the subsection A of this section to ensure those policies establish each component of the model policy on or before April 15th, 2018, and comply with subdivision A1 of this section. We think this is important, the reference to A1 within sub B when it speaks to the certification of compliance, because that's specifically speaking to the section that talks about the ability for municipalities to go in above and beyond what the model policy is. We have concerns from what we've heard previous witnesses testify to, that there are some municipalities that are not currently in compliance or deemed to be in compliance because they have more restrictions, especially as it might relate to communications with federal officials related to immigration enforcement. And the goal of these amendments was to get the state out of the business of determining if policies adopted by these agencies comply with federal law, and to focus on ensuring that they encompass at least the components of the model policy. And I just wanted to bring in some testimony from 2019 that speaks to this. In testimony to the House Judiciary Committee on February 27th, 2019, David Scher, representing the Attorney General's office, testified, "The final sentence of B, which we talked about before, makes it clear that a finding of compliance with this law does not constitute a finding of compliance with any other applicable law. And this is to make very clear that the findings of our office and of counsel are making no representation with regard to federal law. We believe that it's perfectly possible for us to make a finding as to whether subdivision A1 is met without also having to make a representation about compliance with federal law." So I think that speaks to at least our understanding of the statute and understanding of the statute as it was crafted at the time. We have concerns that without further clarification or legislative action, that legislative intent might not be appropriately carried out, and that those municipalities who go above and beyond the base requirements of the model policy will encounter issues gaining certification. Now, on the flip side of the coin, we heard that there's a couple of different agencies who are not fully in compliance, one of which I believe is the Essex County Sheriff's Office. And this is of concern because there's reporting about an open disregard for this policy. And we're actually in litigation with that office right now to get better access to their records regarding communications with federal officials. This case arose out of comments made by the sheriff, who was reported saying, quote, "People in his relatively remote part of the state got shaken up when they see unfamiliar folks. Up here," he said, "everyone basically knows everyone. Colby said that he would likely call immigration authorities after a traffic stop if he thought the people in the car were undocumented. Such a call would likely violate the fair and impartial policing policy and potentially, and if based on race or other protected categories, could also violate the Constitution." So those are two sides of the coin that we have concerns about with the policy and application, less in terms of the substance of the policy itself.
Did he just say it or did he do it?
That's what we're trying to find out. That's why we're in litigation trying to get the records about those communications, but as reported publicly, that is concerning.
Thank you.
So in looking forward and potentials to clarify the existing FIP, we think that there's potential for legislative action in terms of clarifying the intent of the 2019 amendments when it comes to determining that the state model policy is the floor, not the ceiling. And then we also think there's greater opportunity in the realm of data collection, as was mentioned before, when one of the concerns is the frequency and volume of communication with federal immigration authorities as defined in the fair and impartial policing policy. We don't think that this would impede the actions of any law enforcement, but if we could get data on how often those communications are occurring, it could give us a better understanding of the actions of law enforcement now. And I think also the flip side of the coin could also help us understand though other instances where there is collaboration between immigration authorities and law enforcement, which we've heard about in testimony today. So if the legislature is looking to address some of the concerns with the FIP, those are two of the areas that we think they should look at. And before I open up for any more questions, I did want to speak to Representative Rachelson's question about emerging technologies and how that might play out within the current FIP. So if you look at Section 6, this speaks to collaboration with federal immigration officials. It pretty clearly provides in the model policy that this is not in violation of 1373 or 1644, but that there can be restrictions on other types of information collected by law enforcement. This includes physical appearance, vehicle license plate information, social security number, lack thereof, family relationships, places of residence, work or education, telephone numbers. So in subsection 7 of the policy, it states that that officers and agencies shall not share any information other than information regarding to citizenship or immigration status about an individual with federal immigration authority unless there is justification on the grounds of public safety or law enforcement needs that are not related to immigration enforcement. And providing such information, agency members should consult with their supervisor. So I think when it comes to the sharing of outside information that might be collected from new and emerging technologies, whether it's Ring cameras or license plates readers, I think the policy is pretty clear that information should not be shared, that we might have a larger funnel. The information is coming in due to emergent technologies. The spigot by which it might go out has not changed, and there are still restrictions around that in the model policy as it relates to things other than immigration status.
Questions? Senator Bohowski.
That is really helpful in terms of data sharing. And I raised this question after Representative Rachelson asked her question around data collection or data sharing. My concern is about how the fair and impartial policing policy addresses data collection. As I pointed out earlier, we have seen in other places the disparate implementation of surveillance based on biased information. And I'm wondering if you feel that the fair and impartial policing policy is adequate to address that, knowing that we do have some statutory language around how this technology is currently used. It doesn't mean we have that for how it could be used in the future.
I mean, the fair and impartial policing policy does speak to a number of instances in terms of what law enforcement officers can ask of folks, especially when it relates to traffic stops and other areas. But I'd be happy to think a little bit more and look into how that might relate to other emergent technologies as opposed to a more traditional roadside stop, which I think a lot of this is trying to address.
Thank you. That would be really helpful because that's sort of my read as well, is that it is trying to address a more traditional roadside stop. And I think there's a lot of places where emerging technology is moving in different directions so that might happen less or differently, so that would be really helpful. Thank you.
Falco,
Oh, yeah, go ahead.
Falco, I have a question that it might be more so for Julio, but I also want to get your thoughts on it. We had heard earlier, there was a pretty stark picture painted in terms of grants and funding from the federal government and cooperation between the federal government and state law enforcement in the event that communication exclusively about immigration is further restricted. And we also heard earlier about the anti-commandeering doctrine. And so, part of which alludes to shifting the responsibility of enforcing regulation onto the state and shifting the cost burden onto the state for federal regulations. Do you have any thoughts? Do you have any thoughts on that issue and how it relates to this entire conversation that we're having?
Yeah, I'd be happy to speak to that. And I think Will alluded to this somewhat, that this is an open question right now across the country as to the constitutionality of 1373 and 1644 in terms of anti-commandeering. There has been different decisions in different circuits on this. Within the Second Circuit, it has been upheld. And I think that's important to notice and to recognize that the Second Circuit where we sit, it has been upheld to this point. Though I think there's And the other question is whether it's constitutional on its face. And then the second question is whether those restrictions on funding can be allowed as well, because they were not directly envisioned by Congress, whether the administration can lawfully restrict those funds due to lack of compliance with the statute when that is not expressly laid out by Congress. In terms of those questions, the Second Circuit jurisprudence has largely upheld the administration's interpretation of this, but other jurisdictions have not. This became moot as this moved through the courts when the Biden administration came into power and no longer attached compliance with these statutes as a condition of receiving funding. So it is still an open question. In terms of our position on allowing municipalities to go above and beyond and to explicitly require that there's a lack of communication with federal authorities about immigration status, as you heard before, I think that is a decision of the municipality itself. And the goal of the 2019 statutes was to get the state out of the business of certifying whether or not they complied with federal law. It is of the business of certifying whether you meet the floor of the model CJC policy, which is in itself compliant with federal law. So if municipalities want to take actions that go above and beyond that, that is their decision. And then circling back around, whether or not that will lead to loss of federal funding or whether that's lawful is still an open question to be decided by the courts. Thank you.
Do you know if there's a circuit split heading towards the Supreme Court on this issue?
I don't believe it's heading to the Supreme Court at this time, but I wouldn't be surprised if there's more momentum around that as new limitations on potential funding come from the administration. As I said before, the Biden administration no longer conditioned that funding on compliance. I think it'd be very likely we see similar actions from the Trump administration conditioning funding on different compliance measures, as we've seen in a number of areas, not just in this area, but a number of areas across state and federal government where the administration is trying to condition funding on, certifying compliance, especially with their interpretation of the law. And many of those have been challenged in court and continue to be challenged.
Right, not 8 USC 1644, but maybe a broader opinion is coming down the pike. So Representative Arsenault and then Senator Mahowski.
Thank you. So I had the same question with our previous witness, but I think I withheld the question because it seemed almost too obvious. I still, it persists in my mind, so I'm going to ask it. With the language we have in A1, specifically, such agencies and constables may include A1 of the statute 2366. Such agencies and constables may include additional restrictions on agency members' communication and involvement with federal immigration authorities or communications regarding citizenship or immigration status. That seems pretty clear to me. So my question is, why are we having this conversation?
I think the Attorney General's office can speak to that more, but my understanding is their interpretation of subsection F, which says nothing in this section is intended to prohibit or impede a public agency from complying with lawful requirements 8 U.S.C. 1373, 1644, to the extent that any state or local law enforcement agency or practice conflicts with the lawful requirements of 8 U.S.C. 1373, 1644, that policy or practice is to the extent of the conflict abolished. So it is my understanding, and I think others can speak to this more, that is where that is what has come into play is trying to square subsection F with subsection A1 and subsection B.
And we've heard that this was not, there didn't seem to be a conflict previously when certain municipalities' policies were approved. So this is a new appearance of conflict.
That is my understanding.
Senator Mahowski.
So presently, there have been multiple instances of withholding of funding based on federal funding based on interpretations. Is there any active litigation around any of those instances that's going on right now? And if so, is Vermont a part of any of that litigation? And maybe you don't know the answer.
And there is ongoing litigation in relation to the potential of federal funds being withheld. ACLU has been involved in some of the American Civil Liberties Union has been involved in some of those cases. Specifically, it relates to Agency of Education and Title VI related funds related to diversity, equity, and inclusion. We've seen some success in that litigation, but most of these cases will be litigated in one way or another. And usually the question is that withholding of funds acceptable based on the enabling statutes passed by Congress, and has the administration been given that authority to withhold those funds by Congress?
Okay.
So we need to move on. We're running about out of time, and definitely want to hear the rebuttal from Julio Thompson on how to read this. Thank you very much, Falco. Very helpful. And Julio, if you can join us. Thank you for being here.
Thank you all. For the record, I'm Julio Thompson. I'm an Assistant Attorney General and Co-Director of the Civil Rights Unit. In connection with the fair and impartial policing policy, I am currently the Assistant Attorney General and have for the last several years been the one who has consulted with the Criminal Justice Council and engaged with stakeholders, including my good friends here from Migrant Justice and ACLU. I've been doing that for many years. I think my first involvement with fair and impartial policing, or the issue of immigration and local law enforcement, I think dates back to 2011, when then Attorney General Bill Sorrell had proposed a model policy that wasn't binding, but it was a recommended policy. And in conjunction with working with Migrant Justice and the Human Rights Commission, that was Migrant Justice under Brendan O'Neill, who was the executive director then, it included provisions relating to immigration. So it's a familiar subject to me, and I think that's why people have checked in with me over the years, including Dave Scher when he was at our office, and principally responsible for working with the council when he was in our office. So I'm happy to talk about whatever issue to talk about today, including the issue of certification. I would just say I quarrel a little bit with the phrase rebuttal. That's something that in our office we tend to use in an adversarial proceeding, and I don't read this as adversarial. I'm here to provide some information, and part of my role, I think, is to be a little bit of a historian. I think some history has been really helpful. There's additional history I don't think has been raised yet. It might have been raised in other committees. It wasn't raised this morning, and so I'm happy to provide whatever information I can provide.
I guess then an alternate reading of 2366, given what we heard from the other witnesses.
Sure. So as you heard, 2366 was amended in 2017 to include subsection F that said nothing in the policy is intended to conflict with the lawful requirements of those two federal statutes, 1373 and 1644. And that was in, I think, Act 56. I'm sorry. It might be Act 54.
And which year was that?
2017. And it is correct, historically speaking, that in 2016, there was no mention of 1373 or 1644 in the model policy. However, when the legislature enacted and the governor signed Act 54, Act 54 specifically directed the Criminal Justice Council to revise its model policing policy to include and be consistent with the provisions about 1373 and 1644. So historically, it was not the criminal justice that thought it would be a good idea to insert those statutes into the model policy. They were following a legislative command. And that language remains in the statute for the last 7 years. It is true that in 2019, the legislature amended the law again, and they did a number of things. And one of the things they did was add new language about subsection A, permitting localities to have more restrictions on communications and more restrictions on involvement with federal immigration authorities that might be in the model policy. But while that bill was sort of on the table, the legislature did not remove subsection F. It turns out that also in 2017, a different statute in Title 20 VSA 4652, actually was enacted before the inclusion of the FIP the amendment of the FIP policy or statute that has the same language. So Vermont in Title 20 has two separate statutes that specifically say that any policy that's in conflict with the lawful requirements of those two federal statutes is abolished. So I mention that because no other witness today has mentioned Section 4652. It was on the books. It was enacted. It was the first bill that was signed by the governor in 2017. I was there for the bill signing. And so the question becomes, did the 2019 amendments to subsection A, did that somehow repeal the subsection F without just striking it? It somehow impliedly repealed it, and impliedly repealed a separate state statute that had the same requirement. So when we construe statutes, we follow what the Vermont Supreme Court tells us to do, which is that when the courts construe a statute, the aim is to give effect to the entire statute. And so subsection F has been there for 7 years. There's never been a vote in the legislature to repeal it. And so we give effect to that statute unless there's some way you can't reconcile the two. So there is this doctrine of implied statutory repeal where a court would say, yes, they didn't outright repeal it, but that was clearly the intent to repeal it. And it's called a disfavored doctrine by the court. You shouldn't presume that the legislature couldn't just cross it out with a red marker, especially when the bill is in front of the legislature and on the same subject matter. And so how can you harmonize the two? Well, the fair and partial policing policy as it existed then and as it exists now creates a space for law enforcement, local and state law enforcement, to communicate information, including immigration status information, with law enforcement if it's an essential element of a crime. Or to have involvement with law enforcement from the immigration authorities if it's unrelated to civil, if it's related to criminal law enforcement and not civil law enforcement. So what subsection A does is allow towns to say, if they so wish, we don't want to have those interactions even on crimes. So even if the model policing policy will allow us to communicate be on the lookout information for a kidnapping suspect, that's allowed under the FIP policy, where you're having involvement with federal authorities. Subsection A allowed towns to say, you know what? I know we're allowed to do that under the policy. We don't want to. We only want to do it for homicides, let's say, or sex crimes. We don't want to do it for property crimes. The towns can choose whatever the permissions are, so to speak, about interaction with law enforcement. And in the FIP policy, it's always on criminal law enforcement, and say, we don't want to get involved in that, even when it means that we might solve more crimes. Our community thinks that the overall effect of being seen next to CBP or ICE officers isn't worth it for maybe this class of crimes. So can you reconcile subsection A and subsection F? Yes, because, and this, I guess it's been mentioned by one witness, but I want to really emphasize it when we're talking about disagreements about that law. Just to keep in mind how very, very small the piece of real estate is that the disagreement is about. And the 2024 amendments to the FIP policy tries to emphasize that to such a great extent. It inserted a table identifying all the sorts of information about individuals that is not covered by those federal laws. The 2017 policy said the same thing, but I don't think it said it so emphatically. And in concert with discussions with Migrant Justice and ACLU, we said, well, things like, do you have kids in school? Where do you work? What kind of car you drive? All of that information is not covered by 1373 as we understand it, because it doesn't relate to citizenship status. It doesn't relate to immigration status. And so our view, and this issue has been adjudicated in the Ninth Circuit out west, California, or when someone's being released from custody, that is not covered by those federal statutes. And so 2024 was an opportunity for the council to say, okay, everybody be very clear. We are not going to share this information because it's not covered by those federal laws. So there's still no conflict. And so that's how you can harmonize the information. You can provide information about someone's location to federal authorities who might be in investigating crimes. And to answer and to refer to a point that was raised earlier, are there federal immigration crimes? Yes, and they figure prominently in the 2024 policy. There are many serious federal immigration crimes. For example, unlawful reentry if you've been removed from the country once after conviction of an aggravated felony. So you are convicted in the United States of kidnapping or murder, you serve your sentence, and then you're removed from the country. Under the federal immigration law, if you unlawfully reentry, well, first of all, aggravated felons aren't, I don't think, given a path for reentry after removal. But if you unlawfully re-enter the country, having served time for an aggravated felony and then been removed, under the federal immigration law, that can be a 20-year federal sentence. And so it figures into the model policy in the provisions relating to whether you keep someone in custody or not. That's under Rule 3 or the rules of criminal procedure. It's pointed out that immigration status should not be considered unless immigration status is an essential element of a crime. And the example that's used in the model policy is someone who reenters after being convicted of an aggravated felony, and pointing out that if someone is facing, if you stop them for a criminal offense, instead of citing them to superior court, it's known to you, becomes known to you that this person, if they are prosecuted for the unlawful reentry, could be facing a 15 to 20-year prison stretch. That may well play into whether they're likely to show up to court as opposed to flee the jurisdiction. And so there are any number of federal laws that govern that are under the immigration code, such as human trafficking, bringing someone into the country unlawfully for the commission of an act of terror or a felony, profiteering off of trafficking, doing it in connection with money laundering. And so these are separate immigration crimes that are enforced by the federal authorities. And the FIP policy says even those crimes are not a priority. But there's still room if there is a money laundering investigation for a town if they are so willing. The FIP policy says if you want to work with them on a money laundering investigation, you can. But if the town says, you know what, it's not worth it to us to have that interaction because of fears in our community, subsection A of the FIP statute says, okay, you can limit that involvement because the FIP policy only says you could do it, not that you have to do it.
Can I ask a question about that? So I want to get to ask you the same question that I asked our witness, the ACLU, and I'm wondering if you can explain. You've said a lot about the interplay of A1 and F, sections A1 and F, and I think I understand that. It sounds like there's been a change recently, that there were policies, municipalities wanting to go further, wanting to take advantage of the provision in A1, but that their policies will not be certified. And that in the past, I don't know, and I haven't seen the policies, I don't know how similar they are. So I'll ask you if there are issues with those specific policies and just how far they want to go, or just what's happening with the failure to certify.
Yeah, and I think this is where I can be helpful to you a bit as a historian. I was not personally involved in this. My former colleague, David Scher, who was an assistant attorney general, was involved in the so-called certification. I don't think the certification is actually used in the statute, but I could be wrong about that. But with those cities. So dates are important here. So in 2019 was the amendment to the FIP policy that added subsection A and said you can have further restrictions. And in our view, and I think a court would agree, Yeah, so long as you don't irk our cousin subsection F down there that says you can't violate the federal law, right? Then the two can be harmonized.
Like bookends.
Yeah.
Okay,
So you can go, I think subsection A says you can go as far as you want, but subsection F is the boundary. You can't go past that. And it's not even up for discussion. The way the legislature wrote the two laws was that there's no process. As soon as you sign the policy, if there's a conflict, it's legally abolished instantly. It's not worth the ink and paper it's written on. That's the mechanism that the legislator created. So with respect to those towns, we've heard that there were 9 towns and they were told by the Attorney General's office that they agreed. But no one has said anything else about that process. And this is where I think I could be helpful. I didn't know this was going to come up today, so I didn't provide you a copy of the letters, or at least the letter that I have. This is to Richmond in 2021. I'm happy to provide that. But it's important. I'll read pertinent portions of it and then provide it to the committee. This is in 2021, so 2 years after the 2019 amendment. And this is a letter by David Scher, who's a person whose testimony, I haven't seen that testimony, but that was cited by the ACLU, same lawyer. And their FIP policy, I don't have a copy of that handy. But the letter that's saying this is in compliance says some important things that no one's mentioned that I think is relevant, highly relevant. And I'll just read his letter if you don't mind. It's only a paragraph or so. In comparing the Richmond policy to the council's model policy, we noted that it did not include any of the model policy's references to 2 federal immigration statutes, 8 U.S.C. 1373 and 1644. Among other things, those 2 statutes provide that a local government entity may not prohibit or in any way restrict any government entity or official from, quote, sending to or receiving from the immigration authorities. I'll just paraphrase that. Regarding the citizenship or immigration status, lawful or unlawful. The next policy the next paragraph just quotes the FIP law that says to the extent any state or local law enforcement, or they quote the state statute, quote, to the extent any state or law enforcement policy conflicts with the lawful requirements of 1373 and 1644, that policy or practice is to the extent of the conflict abolished. And it explains that's why the council's policy put it in there. But here's the key paragraph. As noted above, the Richmond policy does not specifically mention sections 1373 or 1644. However, it does provide that nothing in the policy, quote, is intended to violate federal law. Construing that phrase to mean that nothing in the FIP policy is intended to conflict with the lawful requirements of 1373 and 1644, we can say that the Richmond policy includes each element of the council's model policy. And consequently, we can say that it complies with the FIP statute. So what they were saying at the time was you did not mention the statutes, but our reading, what we were telling you, there are these statutes, the FIP policy requires, and when you say federal law, the condition for our approval is to read it that you are going to follow those statutes. So it's not saying you can ignore it. It's not saying subsection A allows you to ignore those statutes because it impliedly repealed subsection F. It's saying that's the condition for our approval. And if Richmond had come back and said, oh, we don't want to follow that, I could safely say our office would say, we retract our statement about compliance. We're going to go through the compliance process that's set forth in the statute. This letter was, to my understanding, and there are people at the CJC who perhaps are better historians of that. My understanding is that this letter was more or less sent to those other 8 jurisdictions. That I'm not aware of any instance where our office said, you can go ahead and ignore subsection F and ignore subsection 1373 and 1644. The final point historically, from my understanding, again, I wasn't a witness, I'm being a historian here, is that the issue about the state of Vermont certifying compliance with federal law is relevant for a reason unrelated to repealing a subsection that curiously was still left in the statute, which was that at the time, in 2019, there were cities that were eligible for federal grants that needed to certify to the federal government that they were complying with 1373. And the Attorney General's office at the time was, I think, publicly saying, we don't want to be in the position of certifying what cities are doing because we don't know what you're doing. We can only read the policy. And so a certification that your policy, as we read it, complies with 1373 is not a certification that you're actually following your policy, which is what the federal grants say. They say, you agree that you not only that you agree to comply, but that you are actually complying. And while the state of Vermont, because we do represent some state law enforcement agencies, could interact with the client agencies and find out what their actions are, is their practice conforming to the policy? We don't have that authority under the statute to do it for any of the municipalities in Vermont. And so we are making clear that just because we sent the letter, they couldn't send that to the Department of Justice and say, we're in compliance, give us our money. So there's a reason for that. I think that's outside of the issue.
Looking at time, and I don't mean to interrupt you, but I just want to make sure that I'm understanding something correctly, and I think you're the right person to tell me if I'm not. I thought I heard testimony that there have been subsequent policies submitted, that's a fair word, by municipalities that have been not reviewed favorably if certification isn't an official thing. So
I think I can answer that as well.
okay, so is that true? Do I have that right?
Some of this I'm really adding as a historian again, rather than a witness on the scene. But my understanding is that some of the jurisdictions that have still wanted to strip out all references to 1373, having the policy saying you will share no information, which on a normal rating, you would think that would include information. No is no, right? So it would include material that's covered by those federal laws. My understanding that part of the change has been that some individuals, and I don't know who they are, and so I don't want to point fingers because I'm not sure it's accurate. But my understanding is that contrary to 2021, some communities were more vocal that they don't think that those federal laws are constitutional and don't intend to follow it. So what's different between 2021 and 2024, 2025? Well, it's another law that the legislature passed. In 2022, you enacted a statute that's 20 VSA 2359 that says, among other things, that for all law enforcement agencies, your access to certification and training at the academy is conditioned on your adopting and complying with required policies. Previously, with respect to compliance with the FIP policy, there wasn't a statutory sanction. And the statute only said that, that you will adopt and enforce. But in 2022, I think the statute may have gone in 2023, the legislature made it clear that the stakes for compliance were higher. And so the CJC, which both is involved in review and approval and also provides the services, has to decide how it's going to comply with the mandate. So if someone gives you a policy and says, here's the policy, by the way, we're telling our officers to ignore it. Under that 2022 law that you enacted, they would forfeit the right to have academy training and certification. And so what's different is that the law in 2021, when this letter came out, was different because there was an affirmative duty for law enforcement to demonstrate their eligibility to get those academy trainings and certification by showing not just adoption, but compliance. And that was for all policies. So there's a statewide use of force policy and would apply there too. So you have a statewide use of force policy that bans chokeholds. Well, if you had an agency that submitted that policy, yes, we've adopted it. It's stamped by the town. By the way, we're telling officers, do whatever you need to do, including chokeholds. If that came to the council's attention, then they would have to take, the appropriate sanctions that the legislature specifies. So things have changed, but that's because things have changed, right? The towns are saying things differently than they did in 2021. And the law is different in terms of assessing compliance.
Senator Bowski.
Thank you. So subsection F was in place in 2017 when those 9 towns policies were approved. And I don't really see how, because my understanding of subsection A is it's sort of clarifying that the policy, the model policy is the floor, not the ceiling. So I'm confused how, because subsection F was already there, people had to comply with it. Adding in that this is the floor shouldn't change that. But my actual question is, are the Richmond and Hartford policies different than the 2017 policies that were allowed?
I don't know. I don't have them in front of me. I didn't think that was going to be part of our discussion. I think that if a town is representing, we have this policy, but we're not going to follow 1373. Then, you know, in some sense, the CJC, which is a voting body, they have 24 members. And parenthetically, the FIP policy that we're talking about was voted out 24-0. You know, that's their process to find out what's in compliance or not. So in 2021, when they omit mention of the statutes, the condition for approval was, this is fine as long as you're incorporating those. Federal law means that you're applying those federal statutes. But if they subsequently represent that they're not going to comply with those statutes, then they couldn't be in compliance with the FIP statute.
No, I appreciate that. And I appreciate that that is the letter when they were previously approved. But what I don't know, and it sounds like you don't either, is if they are different and if they don't do that now.
Well, there are things that are in the 2024 policy that are indeed more restrictive than, let's say, the 2021 Winooski policy. Like there are provisions there that relate to denying access to people who are in custody in a secure part of a facility. That was a restriction that was recommended by the ACLU and Migrant Justice that the council ultimately adopted. So, you know, I would have to look at each of those provisions, and I just don't have those. There was a mention of Hartford. Hartford has a 2019 ordinance that, again, on its face would conflict with 1373. And so the question is, you know, does that even have, with respect to a police department, does 2366 even give it legal effect when it was enacted in 2019? Or was it null as soon as it was enacted?
All right, well, I think we have to wrap up with that. Thank you for your testimony. It was very helpful. Appreciate all the witnesses as well.